Thanks very much, Mr. Chairman. And I want you to know I really look forward to working with you.
too.
And I think we can work productively together. And Senator Grassley, I want to thank you for the time we worked together. It really was a pleasure, and I had an opportunity to get to know you as the fine person that you are. So thank you very much. I want to say just one word or two or three about women. 25 years ago, there were no women on this committee. I'll never forget watching the Anita Hill hearing on a television in the London airport with a lot of people gathered around. So I went over to take a look, and I saw this all-male Judiciary Committee. And it took all these years, but here we are. And I want to particularly welcome Senator Ernst and Senator Blackburn. I think it's extraordinarily important that this committee be representative of our society at large, and we are growing that way, and so thank you very much for being here. I'd also like to welcome Bill Barr and his family. I know you're proud to be here, and you served as Attorney General before from 91 to 93. And I think we all have great respect for your commitment to public service. When we met, your previous tenure marked a very different, we talked about a very different time for our country. And today we find ourselves in a unique time with a different administration and different challenges. And now, perhaps more than ever before, the country needs someone who will uphold the rule of law, defend the independence of the Justice Department, and truly understand their job is to serve as the people's lawyer, not the president's lawyer. Top of mind for all of us is the ongoing Mueller investigation. Importantly, the Attorney General must be willing to resist political pressure and be committed to protecting this investigation. I'm pleased that in our private meeting, as well as in your written statement submitted to the committee, you stated that it's vitally important, and this is a quote, that the special counsel be allowed to complete his investigation, end quote, and that, quote, the public and Congress be informed of the results of the special counsel's work, end quote. However, there are at least two aspects of Mr. Mueller's investigation. First, Russian interference in the United States election, and whether any U.S. persons were involved in that interference. And second, possible obstruction of justice. It's the second component that you have written on. And just 5 months before you were nominated, I spent the weekend on your 19-page legal memo to Deputy Attorney General Rod Rosenstein criticizing Mueller's investigation, specifically the investigation into potential obstruction of justice. In the memo, you conclude, I think, that Special Counsel Mueller is, quote, grossly irresponsible for pursuing an obstruction case against the president. And pursuing the obstruction inquiry is fatally misconceived. So I hope we can straighten that out in this hearing. But your memo also shows a large sweeping view of presidential authority and a determined effort, I thought, to undermine Bob Mueller, even though you state you have been friends and are in the dark about many of the facts of the investigation. So it does raise questions about your willingness to reach conclusions before knowing the facts and whether you prejudge the Mueller investigation. And I hope you'll make that clear today. It also raises a number of serious questions about your views on executive authority and whether the president is, in fact, above the law. For example, you wrote the president, and I quote, alone is the executive branch. As such, he is the sole repository of all executive powers conferred by the Constitution. Thus, the full measure of law enforcement authority is placed in the president's hands, and no limit is placed on the kinds of cases subject to his control and supervision. This is in your memo on page 10, and I will ask you about it. This analysis included cases involving potential misconduct, where you concluded, and I quote, "The president may exercise his supervisory authority over cases dealing with his own interests, and the president transgresses no legal limitation when he does so." That's on page 12. In fact, you went so far as to conclude that, quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he has a personal stake." You also wrote, "The Constitution itself places no limit on the president's authority to act on matters which concern him or his own conduct," page 10. Later, you conceded that certain supervisory actions, such as the firing of Director Comey, may be unlawful obstruction. However, this too is qualified. You argue that in such a case, obstruction of justice occurs only if first a prosecutor proves that the president or his aides colluded with Russia. Specifically, you conclude, and I quote, "The issue of obstruction only becomes ripe after the alleged collusion by the president or his campaign is established first," end quote. So that's some of the things I hope to ask you about. And in conclusion, let me just say that some of your past statements on the role of Attorney General and presidential power are concerning. For instance, you've said in the past that the Attorney General is the president's lawyer. In November of 2017, you made comments suggesting it would be permissible for the president to direct the Justice Department to open an investigation into his political opponents. And this is notable in light of President Trump's repeated calls for the investigation of Hillary Clinton and others who disagree with him. I believe it's important that the next Attorney General be able to strongly resist pressure, whether from the administration or Congress, to conduct investigations for political purposes. He must have the integrity, the strength, and the fortitude to tell the president no, regardless of the consequences. In short, he must be willing to defend the independence of the Justice Department. So my questions will be, do you have that strength and commitment to be independent of the White House pressures you will undoubtedly face? Will you protect the integrity of the Justice Department above all else? Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. 6 quick yes or no questions. Will you commit to no interference with the scope of the special counsel's investigation?
I will. The scope of the special counsel's investigation is set by his charter and by the regulations, and I will ensure that those are maintained.
Will you commit to providing Mr. Mueller with the resources, funds, and time needed to complete his investigation?
Yes.
Will you commit to ensuring that Special Counsel Mueller is not terminated without good cause, consistent with department regulations?
Absolutely.
If Special Counsel Mueller makes any request, for instance, about the scope of his investigation or resources for his investigation, will you commit to notifying Congress if you deny that request?
I think the regulations require notification of Congress if there's a disagreement.
Thank you. And I have 2 questions from the chairman of the House Judiciary Committee. Will you commit to making any report Mueller produces at the conclusion of his investigation available to Congress and to the public?
As I said in my statement, I am going to make as much information available as I can, consistent with the rules and regulations that are part of the special counsel regulations.
Will you commit to making any report on the obstruction of justice public?
That's the same answer.
Thank you. In your June 2018 memo about obstruction of justice to the Mueller investigation, you repeatedly referred to Mueller's, quote, sweeping and all-encompassing interpretation of Section 1512 which is a statute on obstruction. How do you know what Mueller's interpretation of 1512 is?
Well, as I said, I was speculating. I freely said at the beginning, I was writing in the dark, and we're all in the dark. Every lawyer, every talking head, everyone who thinks about or talks about it doesn't have the facts.
So I spent my Saturday reading that memorandum.
Yeah.
So are you saying this is all your speculation? It's a big memo.
Well, it was informed to the extent that I thought that that was one of the theories being considered. And I don't know how seriously, whether it was being considered or how seriously it was being considered. But as a shorthand way in the memo of referring to what I was speculating might be the theory, I referred to it as Mueller's theory, rather than go in every time I mention it, say, well, this is speculative.
Do you know what Mueller's interpretation of 1512 is?
No, I don't know what Mueller's interpretation. Okay. But, and just one point, Senator, I think, you said in your opening statement, I said he was grossly irresponsible. I think I said if something happens, it would be grossly irresponsible. I was not calling Mueller grossly irresponsible.
I understand. Thank you.
Okay.
I appreciate that. Has anyone given you non-public information about Mueller's investigation?
I don't recall getting any confidential information about the investigation.
Your 2018 in it, you stated, and I quote, "The framers' plan contemplates that the president's law enforcement powers extend to all matters, including those in which he had a personal stake," end quote. Please explain what you base this conclusion on.
Yes. Here's the Department of Justice right here. And within the Department of Justice, enforcement decisions are being made. The president's over here. And I think of it as there are two categories of potential communications. One would be on a case that the president wants to communicate about that he has no personal interest in, no political interest in. Let's say the president's concerned about Chinese stealing trade secrets and say, I want you to go after this company that's being, that may be stealing trade secrets. That's perfectly appropriate for him to do, to communicate that. But whether it's bona fide or not, the Department of Justice's obligation and the Attorney General's obligation is not to take any action unless the Department of Justice and the Attorney General, reach their own independent conclusion that it is justified under the law, and regardless of the instruction. And that's my quote that everyone is saying, I'm sicking the, it's okay for the president to direct things. All I said was, it's not per se improper for the president to call on the department for doing something, especially if he has no personal or political interest in it. The other category of cases, and let's pick an easy bad example, would be if a member of the president's family or a business associate or something was under investigation and he tries to intervene. He's the chief law enforcement officer, and you could say, well, he has the power, but that would be a breach of his obligation under the Constitution to faithfully execute the laws. So, in my opinion, if a president attempts to intervene in a matter that he has a stake in to protect himself, that should first be looked at as a breach of his constitutional duties, whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the emollients clause of the Constitution.
Well, I think there's a dispute as to what the emoluments clause relates to. I have not personally researched the emoluments clause. I can't even tell you what it says at this point. Off the top of my head, I would have said, well, emoluments are essentially a stipend attached to some office, but I don't know if that's correct or not. But I'm sure, I think it's being litigated right now.
I'm going to I don't know either, so I'm going to try and find out. We'll come back another
Okay.
day and maybe discuss it. Your memo stated a fatal flaw in Mueller's interpretation of 1512C2 is that while defining obstruction solely as acting corruptly, Mueller offers no definition of what corruptly means. My understanding is that there's nothing in the public record that sheds light on his definition of obstruction. Do you know what his definition is?
I don't know what his definition is. I read a book where people were asking whether someone was, I think, I don't know if it was accurate, but whether the president was acting with corrupt intent. And what I say in my memo is actually people don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute, and what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on because my time is so limited. You argue that and I quote, the Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor, end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
the Constitution.
the Constitution.
I think it would be. I think it would be a breach of the president's duties to faithfully execute the law. It'd be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position—
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice, first in the spring of 2017, when the investigation was just beginning, and again earlier this year. Is that correct?
No. I had one conversation with him that related to his private representation, and I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the president or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you
Okay.
and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Senator Brett.